So the employee is terminated. Immediately, she calls a coworker to get her to verify the incidents that occurred leading to her termination. And she asks for a statement. Stop. Yes, it's critical to get witness statements, but you want to be sure that you are getting the information legally. Follow the rules. And that's what we're going to talk about today. All right? So let's get started. Pro se, it is critical that you understand if you choose to represent yourself in your case, you should be aware that you will be required to follow the same rules that are required in cases filed by persons represented by attorneys. The American Bar Association Rule 4.2 is pretty standard across the various jurisdictions. It states in representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter unless the lawyer has the consent of the other lawyer or is authorized by law to do so. Of course, you want to look at the rule as it relates to that particular jurisdiction. But in a nutshell, what this says is that as a pro se, you will not be able to talk to or communicate with an employee who worked at the company that you were fired from if that employee is represented by the company's attorney. But I want to get into category of employees, like this one we just spoke about. That is one category. But let's look at some others. The first one is supervisory employees. And I'm going to reference each of these by the American Bar Association rules. But again, you want to look at the jurisdiction's rules, the jurisdiction that the lawsuit will be filed in or has been filed in. In the case of a represented organization, this rule prohibits communications with a constituent or employee of the organization who supervises, directs, or regularly consults with the organization's lawyer concerning the matter or has authority to obligate the organization with respect to the matter or whose act or omission in connection with the matter may be imputed to the organization for purposes of civil or criminal liability. That's clear, isn't it? So let's go to the second category, the former employee. The ABA Rule 4.2, Section 7 states consent of the organization's lawyer is not required for communication with a former constituent or former employee. If a constituent of the organization is represented in the matter by his own counsel, the consent by that counsel to a communication will be sufficient for purposes of this rule. So what are we saying? If the employee is a former employee, generally the pro se can communicate with the employee. Except the pro se need to be careful not to infringe upon the company's privileged information because the privilege belongs to the company or the employer, and it always does. So under no circumstances should the pro se attempt to divulge privileged information. So let's look at the third category, non-supervisory employees. Fact witnesses, current or former. In this case, the plaintiff can generally reach out to bystander fact witnesses. Let's describe these fact witnesses. A, non supervisory employees who do not direct or regularly interact with the organization's lawyers. B, who do not have the authority to obligate the organization with respect to the matter at issue. Or C, whose act or omission in connection with the matter may not be imputed to the organization for purposes of civil or criminal liability. And as always, I like to illustrate these matters with case law. In Timerson versus U.S. Bank, 483 Federal 3rd, 1106, 1126, 10th Circuit, 2007 case. So let me give you the backdrop of this case. Miss Timmerman worked for a U.S. bank. She was subsequently terminated. She sued for sex and age discrimination. And during the discovery period, Miss Timmerman's attorney, Miss Newman, contacted one of U.S. Bank's current employees. And Miss Newman received an affidavit from this current employee. Well, the bank comes back later on and says that Miss Newman never had authority to speak with this current employee. Well, the court cited for Miss Timmerman and said this: it held that plaintiff's counsel did not violate ethical rules by contacting one of the defendant's current employees who lacked authority to commit the defendant to a position with respect to the issue. So, are you getting the difference between approaching a supervisory employee versus a non supervisory employee? And the court continues, as with former supervisors, plaintiff's counsel must be truthful when dealing with bystander fact witnesses. Miss Newman, Attorney Newman, did get an affidavit from the current employee. And I encourage that if you can get in contact with the current or former employee, get an affidavit because you have their signature. It's considered a sworn statement. If you can't get a formal affidavit, get a written statement from the person. If you can't get either, make your notes, memorialize your notes, okay? The fourth category is when representation is uncertain. American Bar Association Rule 4.2, Section 6 says a lawyer who is uncertain or pro se, a communication with a represented person is permissible, may seek a court order. A lawyer may also seek a court order in exceptional circumstances to authorize a communication that would otherwise be prohibited by this rule. For example, where communication with a person represented by counsel is necessary to avoid reasonably certain injury. One such order that a pro se can use to obtain the communication or the testimony of a witness is a subpoena, because the subpoena has the force and effect of an order signed by a judge. So keep that in mind. Well, okay. I know this was a lot, and it is a lot to digest, but it's critical information. I hope this has been helpful, and I will see you next time on Advocate Lucinda. Take care.